Hi, it's my pleasure to introduce Nesam McMillan, who is a senior lecturer in criminology at the University of Melbourne, Australia. Her research focuses on questions of community and responsibility in relation to crime and harm. She is the author of Imagining the International, Crime, Justice and the Promise of Community, which is the winner of the 2021 Hart SLSA Book Prize. And she is co-author of Keeping Hold of Justice: Encounters Between Law and Colonialism. In her broader work, she enjoys collaborative and practice-engaged research and teaching, and working with practitioners, community groups, and other academic colleagues. She recently returned from working outside the university at the Victorian Law Reform Commission on their inquiry into sexual offences. So first off, you're very welcome, Naisam, and I just wanted to ask, could you maybe give a brief overview of your book and why it's important for social-legal scholars?
Yeah, thanks very much, Neil. Thanks for having me. And thanks also again to the Prize Committee, the Association, and Hart Publishing for the Book Prize, which was an honour and a real surprise to receive, especially given all the wonderful books that were shortlisted and published in that year. And I would like to start by also acknowledging that I'm speaking to you today from the land of the Wurundjeri people, where my book was largely written. And I'd like to pay my respects to elders past and present, and to any Aboriginal people that might watch this video at a later stage, and acknowledge that sovereignty was never ceded. And before turning to my own work, I think it's really important to acknowledge the inspirational work of many Indigenous activists, communities and organisations on this continent who have been working to build connection and community before and after harm occurs in a way that's much more grounded and located and collaborative than some of the approaches that I critique in my book. But then to the book itself, most simply, Imagining the International focuses on the ideas of international crime and international justice and how they're given content or represented in socio-legal texts. And I'm particularly interested in the claims to global solidarity and community that are embedded in these ideas. So international crime and international justice are currently popular or dominant concepts, but they're also associated with a really rich and vivid imagery. So international crimes are described as crimes against humanity or crimes against us all. And international criminal justice is said to serve the cause of all humanity, or be able to speak, in the words of Benjamin Ferencz, who was one of the Nuremberg prosecutors, for the awakened conscience of the world. So I started out my book really interested in the ethical and relational potential of these ideas, or more simply, how they make it possible to connect with suffering that occurs in the world and to imagine global community or interconnection. And in terms of the kind of findings or arguments, I argue that on one hand, these ideas of international crime and justice do create a sense of global community and solidarity, in the sense that they are based on and productively imagine an interconnected social world in which the suffering of some matters to us all and will receive an international or an external response. But the majority of the book is spent making the argument that, on the other hand, these concepts are also ethically problematic in the way that they're currently configured. Largely this is because they create what I refer to as ethical and relational distance between those who suffer at any given moment in time and those who don't. And by that I mean that rather than creating kind of grounded, specific and located interactions or relationships between one person and another, or one community and another, they actually serve to position international crime and justice as something quite separate to the world around them, as kind of separate to the lived and the everyday, and therefore don't make those kind of grounded connections possible. One example is that international crime and justice are seen as fundamentally different to other forms of crime and justice, local forms of crime and justice. and they're different because they're somehow higher, better, more important, or more atrocious. So international crime is exceptionalized as particularly odious or characterized by its particular degree of horror, and it's referred to in the International Law Commission's debates as a special category of crime that's quite different to all other categories of crime that we might have encountered so far. While international criminal justice institutions like the International Criminal Court are seen as somehow existing on a higher plane and dispensing a more kind of impartial international form of justice, and they're more specifically understood as everything that local and national justice institutions are not. So they're defined in contrast to these type of institutions, and they're understood as separate from geography, culture, history, and indeed any kind of fixed legal tradition. And I argue that when international criminal justice and international crime are understood in this way, they're understood as fundamentally separate to the world around them, to the lived and the everyday. And because of that, they also don't enable grounded and specific relationships between external parties and people who might be suffering in a particular location at a particular time. So international crime, when it's seen as kind of the worst or particularly exceptional or special, is not seen as a kind of livable and potentially survivable experience. And it's not as possible to connect with the people and communities that might have experienced international crime in their specificity, in their complexity, and with a proper accommodation of their resilience and their agency. While international criminal justice is by definition seen as completely separate to the world around it. So when you cross through the doors of the International Criminal Court, for example, you're said to enter kind of international territory rather than the territory of The Hague, where it's actually based. So in this sense, my book is motivated and committed to a sense of international solidarity and responsibility, but ultimately quite skeptical of the potential of these ideas of international crime and justice as the kind of means or the vessels through which to pursue that type of responsibility. So it's a fairly conceptual analysis, and what I hope it contributes to the existing kind of excellent work on international crime and justice, humanitarianism, and so on, is more of a sustained empirical analysis of cultural understandings of international crime and justice and how they're actually given content in contemporary and archival texts. And also one that demonstrates both the importance of these ideas in the current moment, but also the importance of the way in which they're given content or made to mean. And in terms of critiquing them and offering quite a wholesale critique of them, I hope that kind of critique maybe makes room, some conceptual room, for new or alternative approaches to pursuing international community and solidarity that might be more grounded in time and place, that might be more respectful of the specificity of the communities and people who experience harm, that might be less punitive and reliant on kind of punitive approaches, and also that might be more reflective of what it means to pursue global solidarity and community in the wake of colonialism, which was also very much a global and globalizing project. Oh, I think you might be on mute, Neil, is that right?
Sorry. Brilliant. Thank you very much for that wonderful overview of what I thought, by the way, was a really excellent book. And personally, I've been recommending it to PhD scholars and anybody that's kind of interested in international law. Anybody that will listen really have really been sort of trying to sort of recommend your book, because what I felt about it was that it made me think about international law quite differently, and I think I would hopefully try to be quite critical most of the time anyway. But it just gave me an additional sort of way of looking at international law and international crime. And for that, I just thought it was a really excellent book. So thank you very much for it. Well, moving on to the next question, why do you think it is important to be critical of international criminal law?
Thanks. And I guess just to, say thank you very much for those kind comments, and also that I didn't necessarily set out to be as critical of international crime and justice ideas as I ended up being. So it's kind of interesting to be at the other end and being quite skeptical of their capacity to be a way to kind of foster ethical relations. But back to the question about being critical about international criminal law. So I guess the aim is not to start out by necessarily being critical, but to emphasize the importance of interrogating the claims that are made in international criminal law's names in order to, I guess, enable a more nuanced understanding of whether those claims bear out, but also what international criminal law can offer as, a form of practice, and what it can't. So international criminal law, as I kind of talk about in the book, is currently both a powerful and a valorized framework for engaging with harm and suffering in the world. So events of harm, when they occur, are now frequently denounced or criticised by using the terms of international criminal law. So they're denounced as an international crime, as a genocide, or as a crime against humanity. And there's often a call for an international criminal tribunal or legal process to be set up as a response. And so in this sense, international criminal law is powerful in the sense that it frames how suffering is understood discursively. And it also frames the response that it might receive in practice. So through the building of courts, the arresting of perpetrators, and the trying of individuals. And that occurs as opposed to the range of other actions that might be taken in the wake of harm. And crucially, international criminal justice is also what I'd call a valorized framework, in the sense that it's seen as somehow innately humanitarian or ethical. It's seen as a good and positive response when harm or suffering occurs. And it's also seen as one that in some ways feels difficult to question as much as I've tried to. And this valorization is clearly central to its power and the way that it acts as a framework for our understanding of what should be done when harm occurs. But these ways that we think about international criminal law are really quite different to how we might think about national or local justice processes. And we might be more willing, for example, to acknowledge that national or local justice processes can be punitive and retributive, that such justice processes, because they're undertaken in the name of the community, don't always serve the needs of victim communities, and also that such justice processes have their own power dynamics and biases, and are as reflective of biases as they are of community sentiment. So I guess I think it's really important to take seriously the claims that are made through ideas of international crime and justice, claims to global community, to international solidarity. But what my book tries to do is actually trace how they make it possible to connect with the suffering of others. And I hope that this type of critique enables nuanced discussions about what these processes can and can't achieve, because clearly retributive kind of legalistic processes are only one way that we can respond to suffering, and they have particular effects and particular investments. But also, and this is something that others talk about more fully than I do, I hope that it prompts a bit of reflection and engagement with what it means to pursue a new kind of global legal project in the wake of global histories of colonialism, and also what Anthony Engie and others have shown of the colonial history of international law itself. But I guess again, this is a conceptual argument and critique, and one that it's particularly well placed for academics and universities to make. And in making those types of arguments, I also don't want to detract from the practical day-to-day work of communities and advocates who are using the international criminal law and international criminal justice institutions to call for accountability, because I try and acknowledge in the book as well that there clearly is a demand for accountability through international criminal law, and people working tirelessly to meet that community demand. Sorry, Neil, I think you're on mute again.
I'll try and keep mute off. It's 8 o'clock in the morning in Belfast at the moment. It's 8 o'clock in the evening, I think, in Melbourne.
Yeah.
In your book, you discuss issues that emerge when criminal law becomes a matter of global concern. For example, you talk about the special elements of international law and how it aggrandizes crimes. Why, in your view, is this problematic?
Thanks. Yeah, so in the book, I'm concerned with how the particular way in which an event or a harm or a crime comes to matter beyond itself and comes to be seen as globally or internationally significant. So in terms of international criminal law becoming global, I guess I'm interested in how and why it's said to be global, so the grounds upon which it is, and what kind of ways of imagining the global or the international community this enables. And in the book, I argue that international crime and justice become constructed as distinctively global through a reliance on scalar imagery. So in terms of kind of a scale from top to bottom, international crime is literally described as the top of the hierarchy of harm. So this is in the International Law Commission debates, or the head of the parade of the hideous monstrosities. While international criminal justice is frequently talked about as kind of like a gold standard of justice, or actually kind of a higher form of justice that sits above politics, history, geography, and so on. And in a spatial sense and in a scalar sense, international crime is also a concept that's perceived and defined through what I call a zoomed out scalar context. So international crime is seen to affect generalized states and subjectivities. So international crime is crime that affects all of humanity or the international community as a whole, and it's something that, you know, has effects for international peace and security. And it's also a form of harm that is understood to affect groups or a mass of people. So one special rapporteur in the International Law Commission debates even says, if such a crime affects the individual, it does so indirectly. And so, as I mentioned before, these kind of forms of understanding international crime and justice are problematic in my view, because they actually serve to create a distance or disconnect between external parties and the specific individuals and communities that might experience international crime. So spectacularizing international crimes as the worst of the worst doesn't make it possible to connect with these experiences as livable, survivable, and so on. It also creates a kind of hierarchy of crimes, which if some matter more, some are by definition matter less. And seeing international crimes as a form of harm that only affects groups or a mass of people, again, makes it really difficult to connect with the specific people who experience these harms and the specific meaning for those harms in the context of their, you know, day-to-day lives and their communities' lives. And by tying the idea of the global significance of these crimes to the fact that they harm humanity, there's a sense in which their significance or the way in which they matter is because they affect other people or other states and subjectivities rather than the people they most directly impact on. So they are global because they affect humanity, they affect international peace and security. They're not global because the particular people and the particular communities that experience them and their experiences matter globally and beyond themselves. And I tease this out a little bit more in relation to the Rwandan genocide, but I argue that this is an appropriative move where the lived and direct experiences of some people are actually appropriated in the course of a broader project of building this idea of international criminal justice.
So moving on, maybe just to mention the Rwanda case study. So you use that in the book, stating that it's understood as a Western event on page 41. What do you mean by this, and why is the international response to Rwanda problematic in your view?
Thanks. Yeah, so a key case study in my book is the Rwandan genocide and the international response that it received, and how this has been culturally understood in the aftermath of the genocide. So again, I'm concerned with the same question of how this event or harm comes to be understood as global or of broader significance, and the types of ways in which this enables external parties to relate to this event. So I argue that the post hoc response, or the post hoc global attention to the Rwandan genocide, is tied to dominant portrayals of this event as one that has implications and effect for Western people and communities. So despite the lack of intervention to stop the killings at the time that they occurred, the Rwandan genocide is now a well-known event throughout the world. And there are claims, and this is a quote from the authors of the responsibility to protect, or some of the authors or architects of the responsibility to protect, that there should be no more Rwandas. And there's a general sentiment that if something like this were to happen again, there should be a more interventionist response. So in this sense, somewhat belatedly, even though there wasn't global engagement with the genocide at the time, it's now seen to be a very globally important event. And while I think it's really important and good that this event is seen to have implications for others throughout the world, I try to problematize the grounds upon which this event has become important, because I argue they're self-focused and appropriative. And by this, I mean that non-Rwandan communities, and I'm referring mainly here to Western communities, have come to know and care about the Rwandan genocide as a moment of their failure and their shame and their lessons learned. And in this sense, again, similar to what I was speaking about in relation to international crime, the Rwandan genocide becomes important because of its implications for others, because it was also, it also had implications for the West, rather than primarily because of its impact on the Rwandan people, and specifically the Rwandan Tutsis. And so I argue that such ways of understanding are appropriative in the sense that they borrow the lived experiences of some to pursue other projects. And in this case, the project is more around the representation of the West as the global saviour, even though it failed to be that at the time. And so I guess related to that, my critique of the Rwandan, the cultural understandings of the Rwandan genocide, is also that they rely on really problematic colonial imagery in relation to international responsibility, rather than enabling kind of post-colonial approaches to that. So through and in these understandings, the West is positioned as a potentially benevolent saviour who could have intervened but didn't. But what's not part of these discussions is all the ways in which Western countries were intervening and had been intervening in a way that set up the social, political, economic and historical conditions under which the genocide occurred. And that's a point that's been made by other scholars of the genocide too. But for me, the Rwandan genocide is a really important example of how it's not just enough for something to be seen as globally important. It's actually really crucial from an ethical standpoint to think about exactly how and why its importance is configured, and the types of relationships that creates on a global and specific level.
That's brilliant. I have loads and loads of other questions, but I'll maybe leave them for a discussion, hopefully, when we get to meet at the conference later in the year. Just because I really found it to be a fascinating book, and I would really recommend anybody really to go out and pick it up. It's a wonderful piece of social legal research, and I really want to thank Nesam for giving up her evening to speak to me this evening. So I just want to say thanks very much, and well done on the prize, and well done on such an excellent piece of work. Thank you.
Thanks so much, Neil, and thanks again to you and the association.